May I, Lordship? Lordship, I beg to mention item number 33, Lordship.
Hmm.
This matter also becomes infructuous, Lordship. I have to take updated instruction, Lordship. Can it be other side is there, Lordship?
Mr. P. Sharma, learned standing counsel here, this is submits that he be granted 2 weeks time to obtain updated instruction and appraise this court as to whether any live issue still survives in the writ petition. Since the prayer is made with the consent of Ms. S. Tempai, learned counsel for the petitioner, the same stands alone. Let this writ petition be listed again after 2 weeks.
Please. I beg to mention item number 14, Lordship. In this matter, Lordship, Dr. B. Ahmed is
What do you want? What do you want?
for adjournment, Lordship. It will come after 4 weeks.
On the prayer of learned counsel for the petitioner, admission hearing of this matter still adjourned for 4 weeks.
Lordship, item 25, Lordship, may be adjourned for 2 weeks, Lordship. I've taken the consider of the other side, Lordship.
You are for whom?
I'm for the respondent side, irrigation department.
On the prayer of Mr. Anupadhyay, learned SC irrigation made with the consent of the petitioner's counsel. Admission hearing of this matter stands adjourned for 3 weeks. List accordingly.
Lordship, I beg to mention item number 18, Lordship, with the consent of the petitioner side, Lordship. Lordship, kindly
You are for whom?
respondent, Lordship,
Which respondent?
GU,
Your name, please.
MD Sharma.
What do you want?
Lordship, kindly adjourn the 2 day, Lordship.
On the prayer of Mr. N.D. Sharma.
1 week time,
Counsel for the respondents made with the consent of the petitioner's counsel. Admission hearing of this matter stands adjourned for 4 weeks. List accordingly.
May I please, Your Lordship. Your Lordship, I beg to mention 4 writ petitions, Your Lordship, take together for listing, Your Lordship, on 3rd August, Your Lordship. Oblige, Your Lordship.
May it please your lordship, item number 45, my lord. Lordship, this matter has already been complied with, lordship. So matter may be closed, my lord.
You're right.
Item 44,
Miss B. Bora,
lordship.
learned counsel. 45, is it?
44, my lord.
44. Miss B. Bora, learned counsel for the petitioner submits that order of this court has already been complied with, and therefore nothing survives in this contempt case. Taking note of the submission of Ms. Bora, this contempt case stands.
May I please, Lordship, I beg to mention for listing for withdrawal, my lord. Use the. Well, I beg to mention item 11, my lord, with consent of the other side. I'm from the respondent, my lord. This matter we list after 3 weeks, my lord.
Mr. S.K. Mehdi, learned CBC, with the consent of the petitioner's counsel. 6, adjournment of admission hearing of this case for 3 weeks. In view of the grounds stated by the learned CBC, and since the prayer is not opposed, same stands allowed, this case accordingly. Yes.
may I please, Lordship, I beg to mention item number 19, Lordship, kindly adjourn for 2 weeks, Lordship. I have taken consent from the respondent, Lordship.
And the prayer of learned counsel for the writ petitioner made with the consent of the other side. Admission hearing of this matter stands adjourned for 4 weeks. List accordingly. Yes.
May I please, Lordship, Lordship, item number 40, Lordship. With the consent of the other side, we pray for adjournment, Lordship, for 2 weeks. My senior is out of station,
Contempt case.
contempt case.
You wait, we'll see. Let the matter be called up.
Senior is out of station, Lordship.
Rejected. Yes.
May I please, Your Lordship, I beg to mention item number 21, Lordship. Lordship, last evening only we have received affidavit in opposition, Lordship. We have to obtain the instruction for filing affidavit in reply, Lordship.
You inform
For
the
4
other
weeks.
side.
Yeah, Lordship, we have taken the consent of that side, Lordship.
All right.
4 weeks time may be granted, Lordship.
Item number 21.
28, Lordship.
28. Mr. D. Housen, learned counsel for the writ petitioner submits that a copy of the counter affidavit filed by the APDCL has been received by him only recently, and therefore 4 weeks time be granted for obtaining instruction and filing rejoinder. The prayer is not opposed by Mr. A. Borua, learned standing counsel APDCL. In view of the above, admission hearing of this matter stands adjourned for 4 weeks.
Problem is, Lordship.
Yeah, please, lordship. Lordship, I beg to mention item number 3 of today's daily list. Lordship, my senior have some personal.
What do you want? What do you want?
difficulties.
What do you want?
Lordship, I beg to adjourn the matter for today only.
Prayer of learned counsel for the petitioner, this matter stands fast on every day. Yes. Lordship, I'm praying for listing of my case for withdrawal, Lordship. On Monday, withdrawal, Lordship. Yes.
Well, item 1.
May I please, Lordship. Lordship, we are not pressing further in this matter, my lord.
Your name, please?
My lord, PH Kumar.
Mr. P.H. Kaur, learned counsel for the writ petitioner submits that he has instructions from his client not to press this writ petition. In view of the above, now, Mr. S. Datta, learned Standing Council Revenue Department Assam is present on behalf of the
Respondent number one, Lordship.
one. And Mr. R. Dhar, learned additional senior government advocate Assam for the remaining respondents, remaining official respondents. In view of the prayer made by Mr. Kaur, this writ petition shall be disposed of this property. Problem.
Can you peruse the last order, man? 23-6.
Yes.
I have some verbal instructions. I got instructions that this person, this petitioner is neither though it's show cause that he's not working in the PCF, he's not available there also. So we are releasing him in this week, my lord.
If he is
Within
not
this-
working, then how will you release him?
No, my lord, we'll revert back him to the silviculture office. It's our branch, one of the branch of the forest department. But what had happened, he was deputed to the commission. Then he was asked where he will be working after offer of the deputation. He says, I am the resident of Panjabari since the office of the PCF of Panjabari. He wanted to work there. Well, he's absent now, perennially.
No, listen, what is the case here, Mr. Nath?
It's a very simple matter. While I was serving in the office of the silviculturist, I was deputy in Justice.
You were sent on deputation.
My lord,
To which
After-
office?
my lord, the
To assist the
Office-
commission, my lord.
commission, Justice BP Kotaki one-man commission, my lord. Now, commission submitted his report on April 2021. Thereafter, we was all sent back. We reported to the office of the PCCF to send us back
The
to our
commission submitted its report
on my lord,
19/4/21, my lord.
19/4/21. Then secretary, my lord, issued a communication. Annexure C, my lord,
Yes.
addressed to the PCCF to withdraw all the officers. Page 20, my lord. My name appears against serial number 3, my lord, name of the staff. So I reported there, my lord, in the office of the PCCF. Now he has to issue a formal order repatriating me to my parent division. He's not doing that. He's not doing that. So I am neither here nor there.
I invite your lordships in
1 minute,
attention
1
to
minute.
page 26, my lord.
Are you in a hurry?
No, man.
Where is the order of deputation?
Page 18, man.
All right, so you have not been paid salary since?
Since joining, my lord, since 21, April 21.
April 21.
My
Joining means since release.
release, since release, my lord. Because there is no formal repatriation order. Neither they have any order retaining me in the office of the PCCF.
So what,
Only verbal
what is
instruction.
the order you want? What is the order you?
I just want to go back to my parent division, my lord. I have to.
Yes.
They have to send me back.
My lord, will kindly go to page 26. It's a show cause notice, my lord. It reflects the real situation in ground, my lord. It is found as per records, we are responding without authorized leave for the period 24/21. Since the day he was released, the secretary informed. After being released from one-man commission up to 12/9/21, you had applied for leave 13/9/21.
What is this use of word absconding?
My lord, they are not very very much into this kind of, they don't know words, my lord. I apologize for that. But this person, my lord, he was asked verbally, either he wants to work with PCCF or go back to Bokisto. He is a resident of Punjab, but is established in PCCF in a
No, what is this horrible business? You have to pass an order,
No, my lord, now we are relieving him. I have
yes, but you have
instructions.
to pay him his salary till the date of.
No, that will he'll get, my lord, that he'll get.
All right.
That
Heard
lordship,
Mr.
No,
M.
no,
Nath,
I can
Learned
take it,
Counsel
not
appearing
say
for the
anything, I'm only
petitioner.
saying, my lord.
Also heard Mr. D. Gogoi, Learned Standing Counsel Forest Department, Assam, appearing for the respondent numbers 1 to 5. Next up. The writ petitioner hearing, comma, have you finished? Can I
Yes,
take
I'm
the-
sorry, sorry, I'm sorry.
While working as a what, as
Silvica, office of the silviculturist.
working as a junior assistant
My lord.
in the office of silviculturist, comma, Assam. That is the respondent number 5 hearing was sent on deputation to serve under the Justice BP Katoki one-man commission. First up, the services of the petitioner was placed on deputation under the aforesaid one-man committee by order dated 21/9/2020, issued by the additional principal chief conservator of forest. That is the respondent number 3 herein. First up, pursuant to the order dated 21/9/2020, the petitioner had reported for duty. No, before that, you're right. As per the order dated 21/9/2020, the petitioner was to continue to draw his salary from the present division, that is under the respondent number 5. Full stop. Pursuant to the order dated 21/9/2020, the petitioner had reported for duty before the Justice BP Kotaki one-man commission. Full stop. The report of the one-man inquiry commission was submitted before the Chief Secretary Assam on 19/4/2021. Thereafter, by letter dated 24/2021, issued by the Secretary to Justice BP Kotaki Commission of Inquiry, addressed to the respondent number 2, it was informed that the requirement of the staff sent on deputation, including the petitioner, was no longer there, and therefore a request was made to withdraw them from the service of the commission. Full stop. Mr. Nath, next paragraph. Mr. Nath, Learned Counsel for the petitioner, submits that pursuant to the communication dated 24/2021, the respondent numbers 2 and 3 were under a legal obligation to issue a formal order of repatriation of the petitioner. Full stop. However, no such order has been passed till today, as a result of which the petitioner's fate has been hanging in balance. Full stop. It is also the submission of Mr. Nath that ever since 24/2021, the petitioner has not been paid his salary, as a result of which he has suffered immensely. Full stop. Hence, a writ of mandamus has been prayed in this proceeding. Full stop. Responding to the above, Mr. Gogoi, Learned SC Forest Department, Assam, submits that since 24/2021, the petitioner has not reported for duty, and therefore a proceeding is contemplated against him. The Learned SC Forest has, however, submitted on instruction that a formal order of repatriation of the petitioner will be issued without any further delay. First up. After hearing the submissions of Learned Counsel for both the sides and on going through the materials available on record, I find that the facts till the issuance of the communication dated 24/20/21 by the Secretary to the Justice BP Kotoki Commission of Inquiry is undisputed. Full stop. The entire controversy revolves around the period thereafter. Full stop. Although the department has taken a stand that petitioner has not reported for duty since 24/20/21, the fact of the matter remains that there is no office order issued by the authority asking the petitioner either to continue in his deputation post or repatriating him to his parent department. Under the circumstances, to submit that the petitioner has remained unauthorizedly absent is found to be wholly untenable. Be that as it may, since the learned departmental council has made a categorical submission that the petitioner would be repatriated to his parent department and his pending salary area salary would be paid without any undue delay, I am of the view that there no practical purpose will be served by keeping the writ petition pending before this court any further. As such, this writ petition stands disposed of with a direction upon the respondent numbers 2 to 3 to issue immediate order of repatriation of the petitioner, assigning him a proper place of posting. First stop. The respondent shall also take necessary steps for release of area salary of the petitioner for the period aforementioned. Writ petition stands.
Hold it.
Item 4.
May I please, your lordship, my lord, petitioner is the son of earlier Kaubura, my lord. My lord, pursuant to an advertisement, he applied for the post of Gram Pradhan, my lord, and he did well, my lord, but he was not selected, my lord. By order dated. My lord,
You have filed an appeal.
yes, my lord, I filed a
What
appeal.
what has happened to the appeal?
Nothing has been, not registered yet, my lord. 12/7/23, my lord, I filed again. Page
So that is a submission
58.
that he has preferred an appeal and it was not registered. That is his. So
Not
my lord,
registered.
so that is his submission, my lord. Either I have to get an instruction or my lord may direct to expedite it. They will register and they will dispose it, my lord.
In the meantime, some
Alright.
protection.
Take down. The writ petitioner hearing has participated in the recruitment process for selection and appointment of Gao Pradhan for the village Paschim Karua, Moja Sipazar, lot number 8 under Sipazar Revenue Circle in terms of the advertisement notice dated 07/10/2020 issued by the respondent number 2. He had
Three.
also, respondent number 3, he had also participated in the interview. But when the final results were declared, instead of the writ petitioner, the respondent number
6.
6 was shown as the selected candidate. So contending that being the son of erstwhile Gao Pradhan, petitioner was entitled to preferential treatment in the
Yes.
selection process. He had submitted a statutory appeal under section 162(c) of the executive instruction of Assam Land and Revenue Regulation, 1886, before the respondent number
2.
On 12/7/23.
12/7/2023. Grievance of the petitioner is that despite receipt of the appeal, the same has neither been registered nor any order has been passed therein. As a result of which, he has been compelled to approach this court
Yes.
by filing the present writ petition. First up. Mr. R. Dhar, learned additional senior government advocate Assam submits that since the case of the petitioner is that he has already submitted an appeal before the respondent number 2, and considering the fact that an appeal is maintainable in such matters without going into the merit of the matter, this court may dispose of the writ petition with a direction upon the respondent number 2 to consider the appeal and pass appropriate order therein in accordance with law. Similar as the stand of Mr. S. Datta, learned standing counsel, Revenue Department, Assam, appearing for the respondent number 1. First up. In view of the submissions made, revenue Mr. Chauhan is also agreeable to such a direction, but he seeks interim order of protection if such that the matter does not become infructuous in the meantime. In view of the submission made at the bar, without commenting on the merit of the claim and counterclaim of the parties, this writ petition stands disposed of with the direction upon the respondent number 2 to register the appeal filed by the petitioner and thereafter decide the same in accordance with law. Full stop. Facilitating the above, the petitioner shall submit a fresh copy of the memo of appeal along with a certified copy of this order before the respondent number 2 within 10 days from today. Full stop. Heard on the prayer of interim relief. No, heard on the insofar as the prayer for interim relief is concerned, it is hereby provided that if the respondent number 6 has not yet been issued with the order of appointment, the same shall not be done until such time the appeal, the grounds taken in the appeal is considered by the respondent number 2 in accordance with law. Writ petition stands disposed of.
Kamlesh,
May it please your lordship. My lord, the petitioner is aggrieved by his prolonged suspension in violation of statutory prescription, my lord. He was suspended invoking rule 10(2) of the my lord CCA rules. And your lordship knows under rule sub rule 6 of rule 10, a review has to be done within 30 days.
Petitioner is working as what?
My lord, the petitioner was working as my lord finance, deputy manager, finance and accounts.
He was suspended on
My lord, he was suspended on impugn order at page 53, my lord, 21/8/2022. Page 53. By invoking rule 10(2) of CCA rules.
Yes.
And sub rule 7 of rule 10 provides, if review is not done within 90 days, my lord, it will invalidate
there is a
the.
judgment of this court also.
Yes, there is judgment, my lord.
You
So
have got it?
today I have not got it, lordship will kindly issue notice and
No, there is nothing in this. If it is not reviewed in
Yes,
90 days,
Lordship,
it's
yes.
over.
Lordship, I am appealing for the National Highway Authorities. Actually, this order was passed by the IGNO.
my lord, my parent department is IGNO. I was deputed to National Highway Authority, where my lord, I was arrested. And my lord, thereafter I was repatriated. Again, the IGNO authorities have, my lord, issued the suspension order on 21/8. So my lord, as there is no standing counsel, that's why I paid my.
We have to issue notice.
issue notice. And also issue a direction, they have not paid my subsistence allowance. my lord.
All right. Heard Mr. J. Patwari, learned counsel appearing for the writ petitioner. What is the date of this order of suspension? 21/8.
21/8, page 53, my lord, page 53. Third para.
All right. The writ petitioner, while working. The writ petitioner, who is holding the substantive post of section officer in the IGNOU, that is the respondent number.
One, 2, 3, and 4.
Respondent number 1
1, 2, 3, and 4.
was placed under suspension by order dated 21/8/2022 while serving as deputy manager bracket F and A bracket close on deputation under the NHAI, that is the respondent number 5. First up, the case of the petitioner, in a nutshell, is that notwithstanding the prescription of rule 10(2) of the CCS/CCA rules of
CCA rules of 1965.
1965 and the numerous decisions of the Supreme Court as well as this court, the respondents have not reviewed the order of suspension. Notwithstanding, reviewed the order of suspension before the expiry of 90 days. Notwithstanding the same, the petitioner has been continued under suspension till today. Mr. Patwari has further submitted that the petitioner has not been paid a single penny as subsistence allowance, although the relevant rules mandate so. First up, Miss Bora, Lanet, Standing Council, NHAI, appears
Five,
for
six,
respondent
seven.
numbers 5, 6, and 7, and prays for some time to obtain instruction in the matter. Issue notice of motion returnable on, tell me the date,
My lord, after 4 weeks, my lord.
returnable in 4 weeks. Since Ms. Bora has appeared and accepted notice for respondent numbers 5, 6, and 7, no formal notice is required to be sent to the said respondents. Petitioner to take steps for service of notice upon respondent numbers 1 to 4 by registered post with AD within 4 days from today. First up, hard on the prayer of interim relief. The said prayer will be considered on the returnable date. It is however made clear that pendency of this writ petition shall not be a bar for the authorities to release the subsistence allowed due and payable to the petitioner in accordance with the act.
Deeply obliged.
Obliged.
May I please? My lord, the impugnment order at the lordship will find at page 56. Now, my lord, 57 is the, my lord, operative part, my lord. Last paragraph, my lord. Due to this above gross irregularities and the non-performance in business, you are terminated from CSP job with effect from 3rd June 2023. Bearing CSP number so and so, location so and so, and accordingly, the code is blocked from all services. Now, my lord, no notice, my lord, no show cause, nothing, my lord. And their visitor report says, my lord, the CSP is functioning, my lord, properly in a normal manner. That report also, my lord, we have annexed, my lord. Lordship will find at page 26. Page 26, my lord. This is the, my lord, visitor registered. Page 26. my lord. We have given the type of, my lord.
Petitioner was in contractual service.
My lord.
So we'll have to issue notice, and if we find that the order is illegal, we'll set aside. What
Right.
else?
My lord, since, my lord, they are contemplating to, my lord, appoint the respondent number 8, my lord, in place of the petitioner, my lord. So till then, some protection may be given.
Lordship,
Yeah,
first of all, Lordship, I am for respondent number 1, Lordship, it's a formal respondent, Lordship. Lordship, this e-Gramin service, Lordship, my learned friend was relying, Lordship. E-Gramin service, this is a company, your Lordship, that will show from the page 18, your Lordship. It's a company, Lordship, and he's an employee of a company, your Lordship. It's not government, Lordship. It's not a government, Lordship, page 18, Lordship. Here it is written deed of agreement. E-Gramin Services Private Limited, a company registered under the Companies Act, is appointed by that companies. So I don't think, Lordship, he has any right as a government employee, your Lordship.
The private limited company.
Under the, my lord, control of the SBI and Reserve Bank of India, my lord.
No, Lordship.
Show me the control. Where is the control?
Yes, my lord, that agreement itself says, my lord.
Where is it?
Yes, Lordship, kindly
What
see.
control? Every financial organization
Exactly, Lordship.
has to take the license of RBI.
Now, Lordship, kindly see the agreement at page, my lord, 18.
Yes.
Yes, my lord, second paragraph, my lord. So and so, permanent resident of so and so is the state of Assam, so and so referred in customer service point, CSP, bearing number so and so, under the link branch SBI Bogriwari.
Mr. Mondal, he is not in service of other authority under Article 12. You will be wasting your time here.
Now, my lord, it is not, my lord, the service. Actually, my lord, is the agency, my lord. They are, my
Or
lord,
it will issue notice
franchise, my lord.
and make it admission maintainability open.
Yes, my lord, that's.
But no interim order can be passed.
Yes,
My
Lordship.
lord,
No.
since Lordship kindly see it, since I am, my lord, holding the CSP, my lord. Now, other person who is from 16 kilometer distance from my village, my
We are
lord.
not concerned. First of all, you must be in service of a public authority.
My lord.
You are in service of a private company.
But under the control of the.
What
SBI and
control? What
the-
control?
No salary.
What control?
The government doesn't pay the salary. Lord.
Who pays the salary?
Pays, there is no pay system, not the commission system is there.
Correct.
The commission system is there.
Mr. Mondal, your client would have had better remedy, but since he will not understand,
Well.
we'll keep it pending and he will suffer. What to
Well.
do?
Let's notice we should.
Yes. Heard Mr. M. O. Mondal, learned counsel for the petitioner, assailing the order of termination dated 3/6/2023. The petitioner has approached this court inter alia contending that the order has been issued in violation of the principles of natural justice as well as administrative fair play. Mr. DJ Das, learned standing counsel, learned
CGC, Lord.
CGC appearing for the respondent number 1, submits that the petitioner was in service under a private entity and therefore the writ petition is not maintainable in the eye of law. Full stop. Having heard the submission of learned counsel for both the sides and on perusal of the amendments made in the writ petition, I am inclined to examine the matter. NOM 8 weeks since Mr. Das has appeared and accepted notice for respondent number 1. No formal notice is required to be sent to the said respondent. Extra copy of the writ petition be furnished to the learned CGC. Petitioner to take steps for service of notice upon the remaining respondents. The question of maintainability of the writ petition is kept open and shall be gone into a stage of admission here.
Much less.
Well, till reasonable date.
I can dictate a judgment dismissing it right now. You won't like it. Your case is not maintainable. I've seen it in the agreement, whatever has to be seen as. If you want that judgment, I can dictate it. Your
I'll-
case is not maintainable.
Yes, I'll try.
That order will be passed after 8 weeks.
I'll try.
Much
But
less.
you will be happy to have this pending for 8 weeks.
Well.
That is the fact of the matter. So that you can tell your client that I have got some order.
Obliged.
So go home on that.
May I please, Your Lordship? My lord, this is second wife claim for my lord DCRG and family pension.
Notice, I think, heard Mr. Yeah, you can have counsel for the petitioner. The second wife of deceased Akhtar Jaman has approached this court by filing the instant writ petition with a claim on the share of the DCRG and family pension payable on account of the deceased. And stuff. I have perused the amendments made in the writ petition. NOM 8 weeks since Mr. F. Dr. Learned Standing Council, Panchayat and Rural Development Department, Assam, has appeared and accepted notice for respondent numbers 1, 2, 3,
1, 2, 3, and 5.
and 5, and Miss
On behalf of respondent number 4.
so and so. On behalf of respondent number 4, service of notice is deemed to be complete on respondent numbers 1 to 5. Extra copy of the writ petition will furnished to the learned department council. Requisite in numbers within a week from today. Petitioner to take steps for service of notice upon respondent number 6 by.
I said 8. No, please, your lordship.
Yes.
My lord, a similar matter came before your lordship few days back. That was in the cadre of superintending engineer getting promotion to the higher up, higher position. Now it is the petitioners are executive engineers and they are getting promotion to the superintending engineer. Gradation list has been finalized, it has been published. Thereafter, the follow-up action has not been taken. According to the rule, it has to be simultaneously, I mean,
The other matter is pending.
no, that has been disposed of. And my lord, your lordship had disposed of the matter on the very day. And the order is available at page 36, my lord. Very day of motion hearing.
Consider if vacancies are there, what is it?
Just one difficulty is there, Lordship. In this case, I do not have any objection, Lordship, but in this case, Lordship, one application is pending by some of the officers in the rank of executive engineer, Lordship. And in that application, they are praying for modification of a stay order, Lordship. If your Lordship passes an order in this case, Lordship, it will have the effect of,
Modification of a stay order.
yes, Lordship.
What is that case
Lordship,
number?
there is a gradation list of 2022 February, Lordship.
Hmm.
And in that stay order, Lordship, court directed not to give any promotion pursuant to that gradation list, Lordship.
Is
and
it there?
Lordship,
What is the number you give?
the
We'll
number, Lordship, that is,
post both the matters
that is
together.
with the entire reservation series, Lordship, that number I am not having at the moment. That is a part of that reservation series case, Lordship.
Then we'll say that subject to further orders that may be passed in that proceeding. That's all.
My lord, that are the petition port, that pertains to reservation issues.
Whatever.
That is,
Yes.
that is, but this gradation is not under challenge. That's the earlier gradation. Man, land is submitting, but that is in respect of the gradation list which was published in the year 2002.
So we'll say that
This is
subject
the new
to-
one. This is not under any challenge, my
Mr.
lord.
Sharma, we'll
Yes.
say that subject to further orders that may be passed in that proceeding. That's all.
But again,
Then
promotion
we
will
can't-
get
then we can't.
affected, my lord. Because the prospect of getting their promotion, there for a limited duration in the department. Their, I mean, year of service won't be extended. Whatever they will get.
Mr. Sharma,
have
I
to
have
get-
understood your point.
Yes.
We are dealing with these matters a little more than you.
Hmm.
You can agree to either of the two. Either this is tagged with these other matters, or
can-
we say that this order is passed, which will be subject to restriction, restraint order, if any, passed in those proceedings. Which do you want to choose?
Later one, obviously.
Later one.
Later one,
All
obviously.
right.
Lordship,
case-
I would like to submit, Lordship. I would be happy, Lordship, if your Lordship pass any order in his favor, Lordship, because they are my officers, Lordship. But it will be my honest duty to apprise your Lordship as regard the pending cases. At
So
least,
give the number, we'll
Yes,
say that
that number.
subject to,
Lordship, what I am submitting, Lordship may not like to add this matter along with those matters. At
No,
least
no,
this
no,
Lordship
not
will
that.
only issue notice,
I'm disposing it of today.
Lordship.
Give me the case number, we'll say that this direction would however be subject to the condition that there is no pending litigation concerning the gradation list in question. That's all.
That number, Lordship, it will take some time.
Can you give it to him later?
Lordship, I can give in to the.
All right, take down. Hard, Mr. So, Mr. Nayak, there is no point in keeping these writ petitions pending.
Yes, Lord.
People want promotion, vacancies are there. They are asking.
Only that is the issue.
So
Lord.
we'll say that subject to no
Yes.
order of restraint been operating in that
And
field.
that matter is pending before the.
All
division
right.
bench, Lordship.
Heard Mr. R. Sharma, learned counsel,
Learned
appearing for the writ petitioners. Also heard Mr. P. Nayak, learned standing, you are appearing as standing counsel,
PWD, Lords.
PWD Assam, appearing for the respondents. Full stop. The writ petitioners herein are posted as executive engineers. Bracket civil, all civil.
All civil.
Civil, under the PWD Assam. Full stop. According to the petitioners, the date of their retirement is approaching fast. Full stop. Since the gradation list of executive engineers, bracket civil, has already been published by the department on
Was published on 24 June.
24/6/2023, and in view of the process initiated by the department for promoting a number of superintendent engineer bracket civil bracket close in PWD to the next higher grade, there is a possibility of vacancies arising in the rank of superintendent engineer PWD. Full stop. The petitioners have therefore approached this court seeking a direction upon the respondents to consider their cases for promotion to the rank of superintendent engineer bracket civil without any undue delay. Full stop. The prayer made in the writ petition prima facie appears to be innocuous, and therefore there is no justifiable ground for this court to decline the same. More so when a similar writ petition filed by a number of superintendent engineer bracket civil bracket in the PWD with a prayer of like nature being WPC number 3445/2023 had been disposed of by this court by the order dated 16/6/2023. Full stop. However, at this stage, Mr. Nayak, Learned Standing Council PWD submits that although he would ordinarily not oppose the prayer made in the writ petition, yet in view of the pendency of a batch of writ petitions along with WPC number ... wherein the central controversy is pertaining to the validity of the gradation list of executive engineers
Yes.
civil vis-a-vis the reserve category candidates. Until and unless the said issue is resolved by an order of the court, it may not be possible for the department to act on the gradation list published on
24/6/2023.
Full stop.
And the earlier gradation list of 2020.
Full stop. Responding to the above, Mr. Sharma submits that the gradation list regarding which writ petitions are pending are pertaining to
2022.
the year 2022, and therefore the same may not have any relevance in the facts of the present case. Be that as it may, next para. The other writ petitions are not listed before this court. The court is informed that the writ petitions have already been heard in part by a coordinate bench, is it?
Division bench.
By the division bench, full stop. If that be so, this court cannot make any comment or observation pertaining to the issues involved in the aforesaid batch of writ petition, full stop. As such, the present petition is being disposed of at this stage of motion stage by providing that the case of the petitioners for promotion to the rank of superintendent engineer bracket civil be considered if they come within the zone of consideration as per the rules, and vacancies are available in the rank of superintendent engineer bracket civil, subject however to the condition that any order passed by the division bench in the pending proceedings in the form of writ appeal. It must be writ appeal or WPC.
It's a petition, it's all the writ petitions, Lordship, but it was an application, IA Lordship, against an order passing the writ WPC Lordship.
And so,
23.
and there is no restraint order passed by the Honorable Division Bench in that regard. Full stop. Writ petition stands disposed of. You just give the numbers.
Lordship, I'm really comfortable.
Right.
No. Zero over.
For admission item 9 and 10.
May it please your lordship. Well, your lordship will recall that this was a case where my termination as a doctor from Oil India Limited was put into challenge. Now, on the
Oil India Limited.
Oil India Limited, Duliajan was put to challenge. I have taken your lordship through all the enquiry proceedings and all. And in the enquiry proceeding was that since I had some affair with a lady in Guwahati, so they have terminated my services, saying that it will accept, vitiate the atmosphere in oil and all. But during the pendency of this petition, although I had challenged my termination order, my lord, in the meantime, my wife and my daughter, who had initiated a separate proceedings before the trial courts in Dibrugarh under the Domestic Violence Act and or other provisions of law for their maintenance and all, they came before this honorable court that
Now, since earlier when I was placed under suspension, when I deposited my subsistence allowance in the joint account of my wife, then my wife used to withdraw all the money. I did not get any money. Then I filed an application before this honorable court saying that if my subsistence allowance is deposited in the account, I don't get a penny. Then the court asks the All India authorities to deposit the money in a separate account. Now, during the pendency of this writ petition, I have already been superannuated from my services. Today, even if the termination order is set aside by this honorable court, what I will be entitled is for the notional benefits on that they may be calculated. In the meantime, my lord, during the pendency of this writ petition, All India has come out with a figure of around or nearly about 1 crore. I think with interest that has gone more than 1 crore because I was going to be the CMD of All India Limited. So on the last occasion, I gave an offer that I have a daughter who is now around 27 and 28 years, who is working in Delhi, I suppose. And I have a son who is also a major. And my wife is a teacher at Kendriya Vidyalaya, Duliajan. So on the last occasion, I gave an offer that 50% of whatever amount the All India authorities have, that I'll give it to my wife and the 2 children. So for pension is concerned, pension will remain for my personal benefit till I die. That was the offer given. Then your lordship had formulated this offer in a paper, and we had gone through it. But at the time of dictation, your lordship found that the daughter and my son was not served, or they were not given notice because there was a separate order in respect of the daughter. Then we filed an impleadment of my daughter and son, and they are now being represented by their counsel. So your lordship will kindly see whether that offer is still in the file or not. I have not gone through the record, my lord. Because the draft copy of that the order of your lordship was showed to us because once we agree to it, then my lord, then your lordship said that your lordship is not going to change it. But on the time of dictation, it appeared that I don't know that offer is still there in the file or not, because it was typed in a separate paper and shown to us, my lord.
We'll check up now. What is to be done now?
My lord, now my offer is that stands as it was given to this court, to this honorable court before. Now, if the opposite party doesn't agree to this 50%, then I have to, then your lordship will pass the order on merit of the case. Then I have to start afresh again because time has passed, sufficient time has passed.
You are appearing for whom?
I am appearing from the only private respondent, my lord. We are basically agreed, my lord, what happened actually. He has deserted me and my children, my lord. Long before, it is in 2013, my lord, when he was working, my lord. At that time, he deserted, and that time they used to maintain a joint account. Then I have filed a DV case before the competent jurisdiction, and under the DV Act, the learned court below passed an order. The order lordship will find page 25 of my IA 2834. And the relevant portion lordship kindly see page 34. The order passed by the judicial magistrate first class Dibrugarh, the monetary relief, paragraph 11. Has your lordship got it?
Yes.
The concerned authority of the employee of the respondent Oil India Limited, Duliajan, is directed to release out of the amount kept aside by interim order dated so and so a sum of 40 lakhs from the terminal or dismissal dues payable to the respondent. The amounts to following manner: the arrear amounts which has become due since order of interim maintenance 12-12-13, a sum of rupees 25,000 per month to the daughter Srimati Shivangi Gogoi and rupees 10,000 to the son Rostov Gogoi. The arrear amount in respect of the daughter should become due till she attains the majority. The amount which shall remain to the hand of the Oil India are making the payments as aforesaid shall be further divided in and paid in the following manner: A sum of rupees 20 lakhs shall be paid in favor of the aggrieved party, mainly Sri Tulika Gogoi, and another sum of 10 lakhs to be paid in favor of Rustov Gogoi. The Oil India Limited shall be at liberty to release the residue if any remains after making all the aforesaid payments in favor of the respondent. Concerned authority Oil India Limited is to cause immediate effect to the transfer the above amounts of total 30 lakhs to transfer in individual bank account aggrieved party Srimati Tulika Gogoi, which is account number so and so to the State Bank of Duliajan branch. Then, my lord, this was the amount due. He had not paid a single farthing to us since then. What he did, in the meantime, he filed a petition, writ petition before this court that his account, which is maintained as it was a joint account, should be transferred to his individual account. And in the grab of that, we are not party to that writ petition. He has also taken an interim order that till it was shifted, that the accounts, this order should not be complied.
Now the son and daughter are also parties here.
Yes, now son and daughter are also party. We are
Who is
representing.
appearing, who is representing?
I am appearing for all pilot. I am appearing.
Acha, what do you have to say? Some arrangement was made last time. Are you agreeable to that?
No, my lord, because the lordship, we are, as on date, we are only concerned because he's also challenges the service.
Well, that part he
That
says.
part we are not concerned. We are simply concerned about the whatever the money
Hmm.
has been directed to be paid by the competent authority.
Hmm.
That should be released to us.
All right, so
And-
therefore these matters will have to be heard. It will be contested by you.
Only that part, because we are already competent authority has passed and because of his writ petition, that is in a different ground. We are not on that ground. Because of his writ petition, All India is not releasing our money. Though it was,
Followed, but these matters will have to be then finally decided.
Yes.
Is it not? Final judgment has to be passed.
that I leave it to your lordship. Because the,
Who's for the all India? Just for-
Otherwise, our role is very.
You have nothing to say.
Nothing to say.
So
The
now
money is not
the entire controversy is regarding how much money
the
who will get.
apportionment of the money. How the money should be apportioned between them. That is.
So
the only
Mr.
dispute.
Kaur, that order, earlier order is not going to work here.
Yes, but then I
But
have to-
is there any chance of any settlement through mediation or something?
Well, the mediation was over. They always, on the monetary part, the mediation failed.
Can you both agree on a workable solution and give it to the
I
court?
have given my offer, 50%.
What is your,
my lord, we will take the instruction, but as of now, if you calculate, it comes around 80 lakhs.
no, that's fine. What I am asking is.
Yes.
Mr. Kaur and Mr. Borak, can you use your good office and come up with a compromise formula? Then it becomes easier. Otherwise, the whole matter has to be heard.
Then the. next
Only
week-
the monetary part remain. I have given my
No,
offer.
Mr. Kaur, I have understood it.
Yes, sir.
All I'm saying is there are no third option. Either people agree or the court has to give a judgment on every aspect, which we cannot do it without a
Well,
hearing.
In the morning also, I had a talk with my friend. When I talk, it is as if the eye of the wife is upon me.
Yeah, that's all right. That's all right. But you say what you want.
Yes.
Accordingly, I will fix the date.
Yes, madam.
If you can work out on a
Yes, sir.
compromise formula.
Yes, madam.
Come up
Yes,
with
madam.
a
Yes,
draft
madam.
that will be
Yes.
incorporated in the order.
My friend will give because she is representing the son and the wife and the daughter. Let him give. I'll convey it to my client and I will prevail upon him to see that. But if they ask if they ask an absurd amount, well, that nobody will agree. I also can't
cannot
make him.
comment.
Yes,
If you both are agreeable, I
Yes,
can defer the matter for some time as
Yes, ma'am.
one,
yes, ma'am.
so that you can work out a compromise
Yes, ma'am.
and give it to the court.
Definitely, ma'am. I'm not asking for anything. I am asking for whatever the court has directed. I'm not asking anything more than that.
That's where the problem, my lord. Now,
That's where the problem, yes.
That's where the problem, because your lordship knows, I am not arguing on the marriage. So far,
Is the order of the court under DV Act under challenge?
No.
But that has been dismissed. He has filed an appeal that has been dismissed. So that has attained the finality.
No, my lord, appeal is not dismissed. One
Yes.
appeal is, my lord, what has happened, my lord, during the of this DV case and all, my lord, there was a mediation proceeding gone.
No.
So my client has lost interest on this case. Your lordship will find even in the case of this, I have the three case.
Mr.
Yes,
Kumar,
ma'am.
see,
That's okay, again on merit and all, my lord, I
the
have
court
given
will
a,
expect
yes,
submissions to be made only on the legal
yes,
and you see matters on record. Let's keep emotional things away.
yes.
It's not good idea to mix emotion with work.
No.
Duty, responsibility, emotions should be separate. All I am asking is, I'm repeating again,
Yes, ma'am.
there are only two courses available ahead,
Yes, ma'am.
two courses. One is since everything boils down to apportionment of money. These are matters where the parties themselves, with a little assistance, push and nudge from your side, they can work out a solution. If the solution is worked out, both sides can get into a peaceful ambience faster. If the solution is not worked out, then we judges have to do our job. For that, we'll hear the matter and give our judgment.
Yes, ma'am.
That judgment may or may not be acceptable to both sides. If one of the sides is I'm not accepting it, it'll go on appeal, things will be lingered. That will take its own course. Do you want to explore the first course? If so, please tell me how much time you
I'm
have.
always open for the first.
We
course.
will suggest a date, we'll fix the matter on that.
My lord, your lordship will fix it on 20th. I'll give the proposal to him as soon
On
as.
28th.
Yes.
2/8.
2/8.
My lord.
All right. Mr. B.D. Cole, and senior counsel listed by Mr. H. Agarwal, learned counsel is present on behalf of the writ petitioners. Mr. A. Sharma, learned standing counsel, All India Limited is present on behalf of the respondent numbers 1 to 4.
1 to 6, lordship.
1 to 6. Mr. A. M. Bora, learned senior counsel listed by Mr. J. Patwari is present on behalf of the private respondent. After hearing the submissions made by learned counsel for the contesting parties, it appears that the only live issue surviving in these proceedings is pertaining to the apportionment of the monetary dues receivable by the writ petitioner after due to the services rendered by him under the Oil India Limited. The respondent numbers 7, 8, and 9 have raised a claim on the said amount based on the order dated
3/11/2014. Passed in 510, CR case 510 C of 2015.
No, it's a DV case,
Yes, my lord.
6/10/2015.
3/11/2000,
Final order, my lord, 610.
610.
Interim, yes, 610.
6/10/2015.
6/10/2015 passed by the Judicial Magistrate First Class, Dibrugarh, Assam in case number 510 bracket capital C bracket close oblique 2013. Mr. Kaur, however, submits that the amount claimed by the private respondents are exorbitant. Be that as it may, this court is of the opinion that there is a possibility of both the parties arriving at a mutually acceptable position in the matter. As such, and on the request of learned counsel for both the sides, these matters are directed to be posted again on 28 7/2022 so as to enable them to instruction. But 28 hearing will not be possible. I'm making
I'll
it very
give the
clear.
proposals. ma'am.
If you
Yes,
want it to be posted only to,
But I'm also indicating today itself, today also, that I'll give the, this 50% I have given, I have also talked with him.
whatever,
And all the
whatever,
clauses,
whatever.
we'll give it
If
in
you
writing.
agree,
Yes,
make a note, give it to me, it will be put on the order.
but we'll get, just like giving the draft issues you will give, I will give, then your lordship will work out a solution.
No, one common.
Yes,
If we agree, one common. Otherwise, it will be adjudicatory order.
yes.
Yes. All right.
Item 12 and 13.
May I please, my lord?
Yes.
Well, I'm appearing for the respondents. In item number 12, my lord, we have item 2020 159520, we have filed the affidavit. This affidavit in the next case is ready, my lord. My lord, give me 2 weeks time. In the meantime, we will have that affidavit also on ready, on record. my lord.
You are appearing for
For Oil and Natural Gas Commission, ONGC, my lord.
All the respondents.
All the respondents.
Mr. P. Bharadwaj, learned counsel for the petitioner is present. Mr. UK Nayan, Manoj Senior Counsel, instead by Mr.
A Hussain. A Hussain.
A Hussain, Madam.
A Hussain appearing for the respondent submits that within 3 weeks from today, the counter affidavit on behalf of his clients will be brought on record. As such, a prayer has been made to post this matter again after 4 weeks. Since the prayer is not opposed, so instance and list accordingly.
Much obliged.
Two petitions, sir, these matters.
May I please, Your Lordship? Lordship, in this case, what happened, Lordship, may you kindly take the WBC number 3024/22, Lordship. This is, what happened, Lordship, the petitioner was selected as the Anganwadi helper, Lordship, on merit. And when she went to join in her service, Lordship, she was not allowed to join. And no order has been passed on what ground she was debarred from joining the post. Thereafter, Lordship, she applied under RTI Act, Lordship, and in the RTI Act, an order was issued by the district social welfare officer, chairman of Anganwadi worker and Anganwadi helper selection committee to the child development project officer, Agamani ICDS project. As per this order, Lordship, since there is some complaint regarding the selection process in respect of the particular Anganwadi center, she shall not be allowed to join in the post. After that, Lordship, we have filed a first writ petition. During the pendency of this writ petition, they have appointed respondent number 5 in my post without informing anything regarding cancellation of my selection. No cancellation order has been passed, but they have surreptitiously, Lordship, allowed the respondent number 5 to join in the post. Against this present petition has been passed, filed, Lordship.
Who is appearing for respondent number 5?
That is what Your Lordship, the process does not reflect whether service has been completed. I did not.
Has the respondent number 5 been served?
Lordship, step has been taken, Lordship.
Yes, respondent number 5 has been served.
Lordship.
I filed an affidavit in the other case, 2199 of 22. That affidavit will serve the purpose, Your Lordship.
Why her appointment has been cancelled?
Because the advertisement said that her education qualification has to be matriculate from a board recognized by the government of Assam. But she has passed it from West Bengal, Your Lordship. Some West Bengal open there. Your Lordship will turn to page number 34, which is the certificate, the class 10 pass certificate.
Page number 34
of the affidavit in I filed in WBC 2199 of 22, Your Lordship.
Yes.
Lordship will see above Paschim Bongo first Robindra Mukta Vidyalaya, Your Lordship. This was the complaint was this, and then once it was investigated, it was found that this was her qualification. So naturally, she could not be selected, Your Lordship. And thereafter, a public notice was given saying that regarding her that is in page number 35, Your Lordship. Next page.
No, where is the advertisement?
Advertisement, Your Lordship, page number 19 of the petition which my learned friend was referring to, 3024, Your Lordship. Conditions.
Page number?
19.
Lordship, serial number 3 regarding education and qualification. And
Page 19, which clause you say?
Serial number 3,
serial
Your
number
Lordship.
3, Lordship.
Please read it.
The candidate for the post of Anganwadi helper shall be HSLC, HMLC pass. In case of non-availability of such qualified candidates, candidates shall have to pass class 10 The school certificate shall be countersigned by the inspector of schools and the mark sheet shall be submitted.
School or product.
Where does it say recognized by
No,
Assam?
no, Lordship, there is a clause, Your Lordship.
Is she a permanent resident of Assam?
Lordship,
Yes.
originally she is from Coachbihar, but she married in Dhubri district, Lordship. 12 years, since 12 years she is.
No, Mr. Hazarika, you see, this stand appears to be very fallacious. Somebody who has obtained a, say, master's degree from Guwahati University.
Lordship.
Can another state say that, sorry, we don't recognize Guwahati University? Can Karnataka or Bengal say that we don't know Guwahati University, so you are not master's degree holder? Can it be said?
It's true, Your Lordship, that.
But somebody who is not
And,
a permanent resident of Assam, yes, those are grounds.
Lordship, one thing which also struck me was that is it, even if we say that this requires the approval of the government of Assam, does it have the approval of government of Assam? This course, if it is the stand of the government, if what we're saying that, okay, this open schooling from West Bengal is not approved. As Your Lordship has pointed out, that suppose someone gets a master's degree from Karnataka, will it not be approved in Assam? So that instruction may I obtain that, okay, is this particular, why are you not accepting it? Because ultimately she has passed.
So is this a genuine institution? That you can say that this is not recognized by the government of that state. Then of course. But the West Bengal Council of, what is this, Ravindra?
Open schooling.
And also, Lordship, at the time of selection, Lordship, her mark sheet, certificates and everything has been examined. As per the advertisement, Lordship, in the vernacular, প্ৰাৰ্থীসকল আবেদন পত্ৰৰ লগত উত্তীৰ্ণৰ ফলাফল মাৰ্কশ্বিট এণ্ড অন্যান্য চাৰ্টিফিকেটবোৰ সেলফ এটেষ্টেড কৰি গাঁঠি দিব লাগিব। তাৰোপৰি সাক্ষাৎকাৰৰ সময়ত পাৰ্চনেলিটি টেষ্ট অৰিজিনেল কপি দিব লাগিব।
What you see Article 16.
Not sure.
See what it reads. But leaving aside that, the advertisement says that it has to be a HSLC. For various reasons, people from this state to that state move. If the reason is not bona fide or legal, then it is another matter. Somebody from Assam may get married to a person from, say, Gujarat or Karnataka. Can the state say that, sorry, we don't recognize the HSLC or graduation or master's degree from Assam? That will be a disastrous thing. But if the person from Assam obtains a degree from a non-recognized institution in Assam, then it is a different matter.
But Your Lordship, that aspect is also, it also struck me that suppose I myself got a degree from Jodhpur. So now will the Assam government say that no, because you did not pass out from Assam, so you will not be recognized or something. So that is there. But only thing
is a difficult position for the REIT court to accept.
Not sure.
We have to go by the constitutional mandate. What is your stand in the counter affidavit?
These 2 points were there. First is
where is it? Can I have a look at it, please? Which paragraph?
Lordship, para 4, page number 29.
Yes. Can you please read it?
That with regard to the statements made in para 2 of the writ petition, the deponent begs to state that it is admitted that the petitioner had been selected as Anganwadi worker in 195 number Rampurhati Anganwadi Center under Agomani ICDS project Dhubri. And it is also admitted that the petitioner was stopped from joining in the said post. However, it is denied that the respondent authority stopped the petitioner from joining on the ground alleged in the writ petition. Rather, the joining of the petitioner was stopped on the basis of legally valid grounds, inasmuch as the petitioner was not at all eligible for the post of helper under ICDS project, because as per the advertisement dated 22/12/2020, a candidate for the post of helper should have qualification of HSLC AHM examination passed from the Board of Secondary Education Assam or its equivalent examination from a recognized board by the government of Assam. But the writ petitioner did her HSLC examination from West Bengal Council of Ravindra Open Schooling and not from the Board of Secondary Education Assam. Hence, the writ petition was not at all eligible for the post of Anganwadi worker.
So if what you're saying is correct, then probably you have a case. But where is it mentioned in the advertisement? That it should be HSLC from a Board of Secondary Assam? Where is it mentioned?
উত্তীৰ্ণ হ'ব লাগিব লৰ্ডশ্বিপ may I take your lordship to para 3 Assamese version your lordship
Where, yes, where is it?
page number 20 your lordship
Hmm.
অংগনবাদী সহায়িকা ক্ষেত্ৰত শিক্ষাগত অৰ্হত প্ৰৱেশিকা অসম হাই মাদ্ৰাছা উত্তীৰ্ণ হ'ব লাগিব যিহেতু প্ৰৱেশিকা অসম হাই মাদ্ৰাছা HSLC HMLC উত্তীৰ্ণ কোনো প্ৰাৰ্থী নাথাক কি অসম হাই মাদ্ৰাছা হ'ব লাগিব কোনো প্ৰাৰ্থী নাথাকে তেন্তে যদিহে তেন্তে নৱম শ্ৰেণী ক্লাছ 9 উত্তীৰ্ণ হ'ব লাগিব স্কুলৰ পৰা প্ৰমাণ কৰা চাৰ্টিফিকেটখনৰ স্কুল পৰিদৰ্শক ইনস্পেক্টৰ স্কুলৰ কাউন্টাৰ সাইন কৰা হ'ব লাগিব লগতে উত্তীৰ্ণ ফলাফলৰ জমা দিব লাগিব
So this clause 3 does not tell you with your stand in the affidavit. It does not say that it should be HSLC from Board of Secondary Education Assam. Where does it say that? In case of High Madrasa, it should be Assam High Madrasa. But she is not from Madrasa.
lordship but
This is not correct.
HSLC your lordship
Where is it mentioned?
I get it, lordship but because the moment the Assam High Madrasa comes in
HSLC is a general term. It applies to all states.
lordship
Is it not?
lordship
High school living certificate is a
lordship
omnibus term.
lordship there's
Or-
one other thing which I have not annexed your lordship maybe that may also this is a notification your lordship I'll show it to my friend and then I'll produce it to your lordship candidate for the post of helper should have qualification of prayer passed in the board of secondary Assam or equivalent exam from a recognized board by the government of Assam like that affidavit of the contact Dada
Yes, what is it?
this is a notification your lordship based on which all the recruitment is done there I have marked a passage your lordship which talks about that equivalency your lordship
So this goes against you.
Lordship, but
This
in
is
the
a
advertise-
notification issued in the name of Governor of Assam.
Lordship, but in the
This because-
advertisement, it
Huh?
is, in the advertisement, this is not. stated,
Advertisement, it may not be, but this will have the force of statute
Lordship.
because it is in the name of the Governor of Assam. These are executive instructions.
But Lordship, when the selection was held, Lordship, original mark sheet, everything has been submitted to the authorities,
That's
Lordship.
correct.
And
Maybe somebody has overlooked it for good or bad reason. But the decision cannot be termed as arbitrary because this notification from 2019
Lordship, yes.
and the advertisement is of
2020.
2020.
20.
So
And-
the advertisement is wrong. The advertisement should have mentioned this.
Yes,
It has not.
no.
If it would have mentioned, your client would have been saved of the agony,
Lordship,
but she would not have got the job in any case.
Lordship,
If you go by the advertisement, their stand cannot be accepted. But
Lordship.
if you go by the notification, then he's right.
Yes, Lordship. And also in the Lordship cancellation, public notice whereby they have said that her appointment has been cancelled. It is not stated that it is due to her education in the outside board, Lordship, her.
No, that will not go into.
It
If
simply
she is
said
not
that
eligible as per the,
Public complaint, Lordship. What kind of public complaint it is not? stated
what do you
in the-
want to do? She is not eligible. What is the point in going into it?
Otherwise, Lordship, as per the advertisement, she is eligible, but because it is stated only about the.
You have already said
Probatica.
that the court has already responded.
Yes, Lordship,
If you repeat it thrice,
Yes,
it's not going to change your case.
Lordship,
This notification is not under challenge.
Lordship.
And what can be done here?
This was not.
You
even
have seen
noticed,
this?
Lordship.
Hmm?
Yes. Lordship.
The
Otherwise,
advertisement is wrong. They should have mentioned it.
otherwise she was selected on merit and she is higher secondary pass.
No, these are posts in scheme.
Lordship.
The state government can lay down conditions. If somebody is aggrieved by the condition, it has to be challenged. But if the conditions say that you have to have a HSLC from SEBA or board recognized by Assam government, under the Assam government, then your client does not fulfill the qualification. Then take your seat. Let me pass the judgment.
That's it.
What to do? Then let me dictate the order.
That's it.
Huh?
No, that's it.
You are smiling. Anything else you want to say?
No, that's it. Otherwise, she is eligible, but on this point only, she is, that's it, or
We will only go by the law.
that's
Is it not? This is a court of law. Whatever the law, we will go by that. The law does not help her case. What can be done? Take your seat. Yes. Which is the order impugned in the first writ petition?
first repetition, let's say this communication annexer E page 26. By which she was not allowed to join in the post clause.
Yes, and the second writ petition is filed against.
Against lordship, the appointment of the respondent number 5 in her post without cancellation of my appointment.
Which page is that?
Lordship, no order has been passed regarding her appointment or anything. Only lordship verbally it was informed that she was appointed and she is presently working. But no order or notice has been issued. Neither my selection has been cancelled, lordship, by issuing any order or anything like that, or any communication has been made to the petitioner.
All right, take down. Any order of appointment issued in your favor?
No, no, lordship, this is the public notice. Public notice is at page 25, lordship. In WBC 3024. It is issued on 26/11/21. Serial number 6. The following candidates have been selected in order of merit. That's it.
Take down. Heard Miss R. Devi Learned Counsel appearing for the writ petitioners in both these writ petitions. Also heard Mr. C.S. Hazarika, Learned Government Advocate Assam, appearing for the respondents.
State respondents.
Of the state respondents. None has appeared for the private respondent number 5. In WPC number 3024 of 2022. Full stop. The facts of the case in a nutshell are that on 22/12/2022, the Child Development Project Officer, Agomani ICDS project had issued an advertisement notice inviting applications for filling up the posts of Anganwadi helpers in as many as 6 Anganwadi centers coming within the jurisdiction of the Agomoni ICDS project, including 195 number NO dot Rampurihati Anganwadi Center, Coastal. Responding to the advertisement notice dated 22/12/2022, the read petitioner herein had submitted her candidature, Coastal. As per clause 3 of the advertisement notice, a candidate was required to pass HSLC/HMLC examination. However, in case of non-availability of such qualified candidates, candidates who have passed class Roman 9 could also be selected, provided the school certificate was countersigned by the inspector of school and the mark sheet was also submitted, full stop. The read petitioner herein had passed HSLC from
Page 34. Your Honor.
where is our HSLC?
Page 34, Your Honor. Affidavit, my affidavit. 2199, Your Honor.
From the West Bengal Rabindra Open University in the state of West Bengal. First up. After conclusion of the selection process, select list dated a select list was prepared wherein the name of the petitioner also finds place at serial number 4. Full stop. Subsequently, a public notice dated 26/11/2021 was also issued by the respondent number 4, publishing the list of selected candidates in terms of merit by granting them 7 days time to communicate their acceptance of voluntary service, failing which the engagement would be automatically cancelled. First up. At that stage, it appears that public complaints were received by the authorities pertaining to the selection of the read petitioner. Consequently, the respondent number 4, consequently, the respondent number 3, that is the district social welfare officer, of Dhubri, had issued a communication dated 30/11/2021 restraining the petitioner from joining as helper in the number 195 Rampuri Hut AWC until further orders. Full stop. Aggrieved by the said communication, the petitioner had approached this court by filing WPC number 2199 of 2022. However, during the pendency of the aforesaid writ petition, the authorities had decided to appoint the private respondent number 5 as the helper in number 195 so and so Anganwadi Center. Full stop. The second writ petition being WPC number 3024/2022 has been instituted, assailing the appointment of respondent number 5 entirely on the ground that without cancelling the order of appointment of the writ petitioner, the private respondent could not have been appointed in the post of Anganwadi helper in the aforesaid AWC. First up. In the counter affidavit filed by the respondent number 4. In WPC number 2199 of 2022, the reason for issuing the impugned communication dated 30/11/2021 has been furnished in paragraph 4, which is reproduced herein below for ready reference. Paragraph 4, quoted here. By producing a copy of the notification dated 25/1/2019 issued in the name of the Governor of Assam through the Department of Social Welfare, Government of Assam, Mr. Hazarika has submitted that unless a candidate has the qualification of HSLC stroke AHM past qualification from an institution from the Board of Secondary Education Assam or its equivalent examination from a recognized board by the Government of Assam, such candidate would not be qualified for being appointed as Anganwadi helper. In the present case, since the petitioner had obtained her HSLC from an organization which did not meet the qualification norms as laid down by the notification dated 25/1/2019, she was not allowed to join. First up, Ms. R. Devi, learned counsel for the petitioner, on the other hand, submits that in the advertisement notice dated so and so, no such requirement was laid down. As such, the ground on which the petitioner has been denied appointment is illegal. It is also her submission that without cancelling the appointment of the petitioner, the respondent number 5 would not have been appointed. More so, since there is no transparency in the process through which he was selected. I have considered the submissions made at the bar and have also gone through the materials available on record. There is no doubt or dispute about the fact that the petitioner had relied upon an HSLC certificate obtained by her from an institution located in the state of West Bengal. As per clause 3 of the advertisement notice dated 22/12/2022, a candidate was required to possess HSLC/HSMLC pass certificate for being appointed as Anganwadi helper. However, clause 3 of the notification dated 25/1/2019 lays down as follows. You have to quote it. It is here. First up. The notification dated 25/1/2019 having been issued prior to the issuance of the advertisement dated so and so, and the same having been issued in the name of the Governor of Assam, such executive instructions, in the opinion of this court, would have the force of a statute and therefore would have overriding effect over the advertisement notice dated 22/12/2020. In other words, since the notification dated 25/1/2019 had clearly provided that HSLC/AHM examination would have to be passed from the Board of Secondary Education Assam or its equivalent examination from a recognized board by the government of Assam, the writ petitioner was clearly not eligible in terms of her educational qualification, since she did not fulfill the aforesaid norm. First up, under the circumstances, it cannot be said that the refusal to issue appointment order in favor of the petitioner, no, the refusal to allow the petitioner to join was arbitrary or actuated by any mala fide intent. First up. It is also to be noted herein that the respondent number 4 had merely published the list of selected candidates, inviting their consent, and there is no order of appointment issued in favor of the petitioner. First of all, therefore, the submission of Ms. R. Devi that without cancelling the order of appointment of the petitioner, the private respondent would not have been appointed, also does not merit acceptance by this court. Full stop. Since the petitioner was apparently not eligible to be appointed as Anganwadi helper as per clause 5 of the notification dated 25/1/2019, the question of validity of the selection process of the private respondent number 4 would not be relevant in the present proceedings. Full stop. The writ petitioner has not assigned the notification dated 25/1/2019, and therefore clause 5 of the said notification would be applicable in the present case. Full stop. Situated thus, this court does not find any infirmity in the action of the departmental authorities in not allowing her to join in the post of Anganwadi helper on the ground stated in the affidavit. Consequently, both these writ petitions are found to be devoid of any merit. The same are accordingly dismissed.
So private restaurant number 5, I heard 4 if I'm.
Private restaurant number 5. Please.
Public.
There will be no order as to first. Please.
File their affidavit in deposition. So 10 days time we grant for reply others. 10 days.
All right, Mr. S. Islam, learned counsel for the petitioner, pays for and is hereby granted each time to obtain instruction and final rejoinder in response to the counter affidavit filed by the respondent numbers 1 to 3. Mr. P.K. Roy, learned senior counsel, is present on behalf of respondent number 1 to 3 and does not have any objection. There is another. List accordingly. Yes.
This is otherwise ready, my lord, this is with regard to termination of the petitioner from service, my lord. It's ready, last question they have asked to file, bring the records, my lord.
We have the records, Lordship.
What is the matter?
When the petitioner has been terminated from service, he was serving as a graduate teacher in the differently able, in the special school, my lord, for the different school, my lord. He was on the ground that he was absent for a long period of time in the service, and there is a sole ground for that matter. The petitioner has been terminated from the service. The challenge, my lord, mainly on the two grounds that, my lord, in the year 2014, there was a shockers and the initiation of departmental proceeding by the department, my lord. But that process could not be completed by the department. And subsequently in the year 2021, again, they have started another process by issuing another shockers and asking the petitioner to file the reply, my lord.
Petitioner has been terminated.
Yes, he has retired also.
So now what do you want?
My lord, his termination was the ground which they have taken, my lord, is not legal so far as.
Why?
Because, my lord, they have taken the ground that we are absent for more than 5 years, my lord. They have started the proceedings in the year 2014, my lord.
And
But this will require full length hearing.
yes,
5-10 minutes will not be enough. So we'll
I-
have it,
in a-
we'll have it on a non-miscellaneous day.
yes, Lordship.
Mr. Deepak will learned counsel for the petitioner. as well
Tuesday,
as-
Lordship.
Huh?
And the date may kindly.
Tuesday in the first week of September.
Lordship.
Ms. A. Talukdar, learned counsel for the respondents, submit that this matter is ready as regards readings and the records are also available. Hence, hence the petition be posted for final disposal at the stage of admission hearing. Taking note of the request made by learned counsel for both the scenes. Let this matter be listed again on 7th of August, the 7th of September 2023 as a fixed item under the column disposal at the stage of admission hearing.
Deeply obliged, Lordship.
I am appearing for the private respondent number 5, my lord. I am praying for 2 weeks' time to file my affidavit, my lord.
Yes. Yes. Mr. M. Sharma, learned counsel is present on behalf of the petitioner. Mr. N. Deka, learned counsel representing the respondent number 5, raised for 2 weeks' time to file counter affidavit on behalf of his client. Since the prayer is not opposed, same stands allowed. And who are for 1 to 4?
Respondent number 4, but our name is not reflecting the cause the thing.
And 1 and 2?
1 and 2 Pollution Control Board, Your Lordship. They filed the affidavit. If a lordship.
That also I have received today.
Oh. You are for?
Respondent number 2 and 3, pollution control.
And who is for 1? Your name, please? MS Sabina Ahmed. Learned counsel is present for respondent number 1. MS
D Datta. D Datta.
T Datta for respondent numbers 2 and 3. And Miss
K. Borpujari.
K. Borpujari for respondent number 4. Full stop. Register to list the matter again after 3 weeks by reflecting the name of learned counsel for all the respondents.
It can be a direction for the UGC to also file their affidavit. That will be the most
the
pertinent
meantime,
of the matter, Your Lordship.
The respondent number 4 may also file counter affidavit.
I'm grateful.
Item 22 and 23.
It is a lordship. Lordship, appearing on behalf of the petition item number 23, Lordship. Lordship, we require a week's time. We have to take instructions from our client, Lordship, whether they want to pursue this matter or not, Lordship. Well, due to certain developments, the matter may have become infructuous, Lordship.
Mr.
N. Gautam, Your
N.
Lordship.
Gautam, counsel for the writ petitioners, seeks posting of these matters again after 2 weeks, so as to enable him to obtain updated instruction as to the existence of any live issue in these writ petitions requiring adjudication by this court. You have for Mr. K. Parasar, Lawrence CGC.
1 and 2.
Is present on behalf of respondent numbers 1 and 2, and Mr. D. Bora.
3 to 7.
Government Advocate Assam, the respondent numbers 3 to 7 are present and do not have any objection. The prayer is adopted.
Item 24.
May it please your lordship. Your lordship, on the last occasion, your lordship, finance department was given time to get instructions in this matter. My lord, the matter pertains to regularization and non-payment of salary. The petitioner was appointed in the year 1992, my lord. Since then, she has been rendering her dedicated services, my lord, in the handloom and textile and handloom and 24. Thereafter, my lord, in the year 1996, 1999, the petitioner filed a writ petition before this honorable court, seeking regularization, your lordship. In 2006, your lordship, this honorable court directed the respondent authorities to consider her prayer on regularization and to conduct the affair to complete the entire proceeding within 6 weeks. That was not done, my lord. Then, my lord, in 2016, the treasury officer of Gulaghat, he sends a letter stating that since her GPF and your lordship may come to page 28, your lordship, annexer 5. Your
Yes.
lordship, since her GIS and GPF was not deducted, her salaries were blocked, my lord. And the respondent authorities were directed to place the present status of her this thing, my lord, regularization process, my lord. Then, my lord, the superintendent of Handloom and Textile, he writes to the director, my lord, seeking her regularization. Now, after around 10 years, they wake up with regard to the regularization process. They initiate in 2016, they start to initiate the entire process, and in 2022, they tell me that that cannot be done. My regularization is rejected on the ground that there is a OM of 2012 state quoting that Uma Devi case, my lord, of the Honorable Supreme Court, my lord. That is the entire case, my lord, and I have not been paid. My services were not regularized, as well as my payment has been held up since February 2016, my lord. That is my case, entire case, my lord.
Your selection was based on what?
My selection was based on, my lord, there was a vacancy that occurred. On that ground, on temporary basis, I was
There was no selection process.
there was no selection process, although my lord, I during my service, I had given interviews for regularization my lord,
My lord, affidavit from finance is required. What happened, my lord? We have already sent it to the government, the Director Handloom, for regularization. Thereafter, my lord, we have filed an affidavit to this effect. Just I will show one page only, my lord. Page number annexure 5 of my affidavit, my lord. Here, the finance department has declined, my lord. So now, because ultimately at the end of the day, regularization, my lord, finance has to approve. So why they have done it, my lord? They are in a better footing to, my lord, explain, my lord.
Lordship, I'll clarify, Lordship, if required, we'll file an affidavit, Lordship. So, Lordship, finance department was implemented, my lords, we were not initially made a party, so the London court raised a query whereby the reason for rejection of the petitioner's case. My lords, I inquired, the finance SIU department received a proposal, my lords, but that proposal was regarding the petitioner being placed as an officiating officer, my lords. That is temporary or an adjustable post, my lord. That is not a permanent vacant post, my lords. So that is why the case of the petitioner was rejected, that proposal, which my learned friend is speaking about. Pursuant to that, my lords, the finance department was, pursuant to that, they had not received any proposal, my lords. Upon being included in the party, my lords, the finance department raised a further query whereby to the Handloom and Textile, I have the letter, my lords, whereby they is asking whether it was against a vacant sanction post, because otherwise we'll be barred by Uma Devi to grant regularization, because regularization of muster roll workers is not allowed, my lords. So there was a query which was raised to the Handloom department, whether it was against a vacant sanction post and whether due procedure of law was followed during the recruitment, my lords. We have not received any instruction regarding that, because of which we can,
it's a 19 July letter there.
Lordship, that was because we were implemented later on, my lord. But the earlier proposal was rejected because of that ground, because as a officiating of it, that is a temporary post, we cannot grant regularization on the basis of that. As a muster roll worker, we are banned, my lords. We cannot grant them regularization. So after that, it has been.
So was it against a vacant post?
No, man.
Then how she had continued for so long?
30 years.
As per our instruction, it was an officiating.
Officiating.
Yes, Lordship. That
It's
is
an
not-
officiating.
That's all
Officiating
right,
as a
but
release.
officiating is her
No, my
term of
officiate-
appointment, but against which post?
officiating in a sanctioned vacant post. My affidavit says so, in the Directorate of Handloom Textiles. In a vacant post,
So officiating is what? It's a temporary appointment,
temporary appointment.
but it is against a sanctioned vacant post. Mr. Chalia, you have to file affidavit.
Lordship, yes, we filed an affidavit, but we have raised certain queries and whether what was the recruitment process, my lords? What was the recruitment procedure followed by the department at that point? Because we have to look into all these
That's
aspects.
correct, but she has spent 30 years.
Yes, Lordship, we came to know about it just recently after we were implemented, because prior to that, we never received any proposal. The proposal which we had received then, we had already taken up.
Heard,
all
Mr. Your name, please?
does, my lord.
A does learn counsel for the petitioner. Also heard Mr. R. Dhar, learned standing counsel, Handloom and Textile Department. Appearing for response number 120 and Mr. A. Chalia, learned standing counsel, Finance Department, appearing for response numbers 4 and 5. The petitioner is aggrieved by rejection of our prayer for regularization in service as well as payment of salary which has been withheld since the year 2016. From the submission of Mr. Dhar, Learned Standing Council, Handloom and Textile Department, it appears that a proposal sent by the department for regularization of service of the petitioner is still pending. However, Mr. Chalia submits that certain queries raised by the department by the finance department are yet to be responded to by the parent department. In support of his above submission, Mr. Chalia has referred to the communication dated. Give the communication. You have a copy?
Yes, Lordship, I have it in my WhatsApp. I can share it. Lordship, a second proposal has not been sent, my lord. Only one proposal which was rejected, my lord.
19 July 2023. According to Mr. Chalia, the first proposal was rejected since it was based on an officiating appointment, but no second proposal has been sent by the Handloom and Textile Department till today. Be that as it may, the controversy involved in this writ petition cannot be conclusively decided without an affidavit being brought on record by the respondent number 4. As such, on the request of Mr. Chalia, 4 weeks time is granted to the respondent number 4 to file an affidavit. In this matter.
Meantime, the respondent, the handloom also
In the
can
meantime-
forward the queries which have been.
The Handloom and Textile Department, Assam, may forward reply
queries.
to the queries and if necessary, submit a second proposal within 3 weeks from today.
Was
Obliged.
Mr. Lordship, my lord, here the petitioner was transferred on attachment basis, my lord. Subsequently, my lord, the registrar by a common order, my lord, passed on 18/1/23 have withdrawn all the attachment orders throughout the state, my lord. That letter, my lord, I don't have now, my lord. I will get it, my lord. 18/1/23.
Yes, your lordship.
Yes.
Registrar has passed an order, your lordship.
Withdrawing all the attachment order.
attachment order all over the state of Assam, your lordship.
Copy at this moment, I don't have. I will produce it, my lord.
What is the grievance in the writ petition?
Grievance that he was transferred on attachment basis from the office of the Assistant Registrar of Cooperative Society, Silchar, to Ramkrishna Nagar, Assistant Registrar of the Ramkrishna Nagar. But on attachment basis, my lord. He was transferred. So this honorable court, we have challenged that as this honorable court was pleased to stay that order, my lord. So now subsequently the registrar by common order, my lord, all over the state has withdrawn all the attachment order. So I have retained in my original post now.
We will close it.
Yes, my lord.
Mr. B. Sinha, learned counsel for the writ petitioner, submits that this writ petition was filed being aggrieved by the
Page 15, my lord.
transfer of petitioner along with several other officials in the cooperation department on attachment basis. However, the order dated 21/9/2022, transferring the petitioner and posting him on attachment basis. However, during the pendency of this writ petition, the order of transfer on attachment have been withdrawn in all cases, and therefore the writ petition has become infructuous. Mr. G. Bordole, Learned Standing the Council Corporation Department, Assam, has also confirmed the said position. Since the petitioner is now continuing in his original place of posting at
Assistant Registrar of Silchar.
in the office of Assistant Registrar of Cooperative Societies, Silchar, by taking note, of the submission made by Learned Council for the parties, this writ petition stands closed.
Item 27.
Lordship, I'm appearing on behalf of S. Borua, Lordship, Granite CGC. She is unable to attend court due to some personal difficulty, Lordship. And she asked me to inform the court that the affidavit is ready and she will file it in 1 week, Lordship.
Yes, Lordship.
Mr. M.K. Bora, Learned Counsel for the petitioner, is present. On the request made on behalf of Learned CGC appearing in this case, this matter stands adjourned for 2 weeks so as to enable the respondents to bring on record the counter affidavit.
Lordship.
Item 29.
I praise your lordship. Lordship, the respondent number says filed an affidavit. Lordship, we would like, lordship, respondent number says filed an affidavit. We would like to file a short reply, lordship.
File when?
Lordship, a week's time maybe given.
Actually, Mr. A. Chakravarti, Learned Counsel for the petitioner, prays for and is granted 2 weeks time to obtain instruction and file rejoinder, if any, in response to the counter affidavit filed by the respondent number.
3, lordship.
Respondent number 3. Miss, your name, please?
Tushi Sinha.
Tushi Sinha.
Yes.
Did I get it correct? Tushi Sinha. Learned Counsel for the respondent number,
All the respondents.
appearing for the.
All the respondents.
Are present and does not have any objection to the query. This
Right.
accordingly.
Item 30.
I do not want to press this case because my grievance has been redressed.
This has Bora Learned Counsel for the petitioner submits that the grievance of the petitioner has been redressed and therefore this contempt case be closed. Mr.
Why would I am appearing for Mr. H. Gupta? Lordship is on legs.
Mr. H. Gupta, Learned Counsel for the respondent is present. In view of the above, this contempt case is closed.
Item 31.
May I please, Lordship? My lord, by order dated 15/5/2023, my lord, respondent number 2 was completed, my lord. But notice was not issued, my lord. So matter, notice may be issued, my lord.
But Mr. A.M.H. Chaudhary, Learned Counsel for the petitioner, it appears that notice upon respondent number 2 has not yet been issued. As such, issue notice upon respondent number 2 returnable in 8 weeks. Petitioner will take steps for service of notice by instant post to the public.
Item 32.
Lordship may kindly fix this case on 27 along with WPC 1374.
On the request of Mr.
2023.
Ashitas, Learned Counsel for the petitioner, let this matter be listed again on 31/7/2023 along with WPC number
1374 of 2023. The other case is fixed on 27, Lordship.
27.
27/7/2023.
2000.
27/7/2023. Lordship.
What is the case number?
1374 of 2023. WPC 1374 of 2023.
On 27/7.
Item 34.
May I please, your lordship, in this matter, we will file our affidavit in reply. So kindly 2 weeks time may be given.
On the pair of petitioners counsel, 2 weeks time is granted for filing rejoinder affidavit. Miss
S. Barik,
S. Parikh,
on behalf of respondent CGC 127. S committee.
is present on behalf of the respondents and does not have any objection. List accordingly.
Item 35.
Yes.
My lord, the other side was supposed to file their affidavit.
This is, who is for the other side?
Mr. Munir was there as the standing counsel Khadi board.
Who is the standing counsel Khadi board?
My lord, Mr. Munir. Mr. Munir.
Can you see if he is around?
Yes, sir.
Time be.
My lord, at 2.
First, let us last till 1, then we'll see at 2. Call him right now.
Item 36.
If you don't find him, then we'll take it next week. We'll take it.
Oh, I said at 2 only because.
At 2 only for this matter, I will not sit.
Oh, okay.
And the matter
I
may not
understand.
last till 2.
Oh, I understand. I'll try to call him.
May please. Your Lordship.
Yes.
Lordship. Lordship, the claim of the petitioner rejected, Lordship, to upgrade them, Lordship, from the post of work size, Lordship, to a regular post, because they were appointed, Lordship, on compensation ground, but on work size basis, Lordship. So their prayer was to, Lordship, upgrade them to a regular post, and Lordship, and it was also
Urban
approved.
water board, he will be required, your lordship. They are under the urban water board.
Who will be required?
Lordship, they are the employees under this Assam Urban Water Supply and Sewerage Board, and they were then appointed on work charge basis. Within bracket, it was given as compassionate
Is
ground.
there
So
a
then-
standing counsel for us?
Yes, your lordship.
Who is the standing counsel?
That I'm-
Then we'll ask the matter to be listed by showing the name in the cause list. Mr. J. Kalisa,
service has been
counsel is
completed.
present on the petitioner. Mr. C.S. Hazankal and a government advocate Assam is present. However, he submits that this matter has to be decided in presence of the standing council of Assam Urban Water Supply and Sewerage Board. In view of the above, register to list this case again after 2 weeks by reflecting the name of learned standing council,
Assam, lordship, the name I am.
Assam Urban Water
RM
Supply
does.
and Sewerage Board in the cause list.
Item 37.
Same lordship.
Same order.
Same order.
Item 38.
May it please the Lordship, my lord, in this case, service on response number 4 and 5 may be deemed complete. My lord, kindly see Lojima court order dated 26 June, my lord. June 2022.
Service on respond numbers 4 and 5.
Yes, my
You are
lord.
appearing for whom?
All the respondent lordships.
All the respondents,
Lordship,
1 to 5.
Lordship.
Then let it come up for admission.
My
Heard Ms. S. Borel and counsel for the petitioner. Also heard Ms. R. Devin and CGC appearing for the respondent. Since this matter is ready as regards service, office to list this case again for admission after 2 weeks.
Item 39.
Lordship, I am appearing for the petitioner.
Yes.
Lordship, we had to serve copies and the department had to get instructions on this matter.
Who is appearing for the department? Mr.
Vaibhav
and counsel is present on behalf of the petitioner. However, the learned standing council irrigation as well as SCBTC are absent, although the names of the council have been shown in the cause list. In the absence of the respondents council, this matter cannot proceed further. As such, list this case again after 10 days.
Obliging.
Item 40.
Your client has already been promoted.
No, Lordship, we don't have the instruction, Lordship. Let it be on Monday, Lordship. So that we can taken instruction from our client.
On the last date, that is March,
Yes, lordship.
you have to say yes or no. If you say he has not been promoted, I'll record your submission. Otherwise, I'll close it. You have no third option.
Okay.
Since last 3 months, 4 months, you can't just sit idle. You make a submission that as on date, your instruction is your client has not been promoted as additional chief engineer, whatever. If you make that submission, then I'll keep it pending. Otherwise, already time was granted to obtain that instruction.
Actually, lordship, I don't have the
All right.
information, lordship. My senior has, maybe I'm unable to contact him.
Sorry, I cannot keep this pending. It cannot.
Let it be
matters
Monday,
cannot-
lordship.
no,
That
no,
is my
no, matters
prayer,
cannot-
lordship.
You ask your client and come back in 10 minutes.
Okay. Obliged.
If he has been promoted as additional chief engineer, matter ends there. Why should we keep it pending? You should have done it
I
earlier.
don't have the contact number.
You
lordship.
find out and get it. Otherwise, we'll close it today.
Item 41.
May I please your lordship, this is an application under section 12 of the contempt code. Lordship order has been passed on 20 June.
Order has been complied with.
No, lordship.
And what if the facts of the case may be considered, my lord? That he was,
So you don't want to comply with the court's order.
my lord, writ appeal is pending, my
No,
lord.
lordship,
Writ appeal, my
writ
lord.
appeal is not pending yet because there is a delay.
And,
And delay is not content yet
My lord,
because.
may I
lordship-
submit, my lord? May I submit? The WPC 5843 of 2010 was pass an order on 26 2022, my lord. Thereafter, downloaded copy of
You have
the,
preferred an appeal against this order.
yes, we have forwarded the copy.
Have you preferred an appeal against this order?
This
Personal
order has
appeal.
not been
Personal
complied with, my lord, because of the pendency of the
No, lordship, there is a
an
delay
application
and
is
on
there,
last
my lord,
occasion.
for under section 5 of the Limitation Act, my lord. He raised an objection in that IA that they have procured the certified copy must after the limitation period. Then the honorable division bench, my lord, directed me to provide fact that he has taken immediate.
R. Das, is it?
R. Kakoti.
R. Kakuti, learned counsel for the petitioner, also heard Mr. A.K. Datta, learned CGC, learned counsel appearing for the respondent. It is submitted at the bar that the respondent has preferred an appeal against the order dated 26/2022 passed by this court in WPC number 5843/2010, and therefore this matter be adjourned for 4 weeks. Ms. Kakoti, on the other hand, submits that the appeal was preferred along with the delay condonation application, and delay is yet to be condoned in the matter. First, be that as it may, since the respondent has preferred an appeal, I am of the view that 3 weeks further time should be granted to the respondent to obtain appropriate order from the appellate court, failing which this matter will proceed in accordance with law. This case again after 4 weeks.
Item 42.
Lordship, when item number 42, Lordship, as per my instruction, there is a possibility that the order has been complied with because I have received telephonic instruction, my lord.
None appears for the petitioner on call, Mr. H. Earlier, learned counsel appearing for the respondent number.
3, Lordship.
3 submits that the order of this court has already been complied with. Mr. A. Hassan is present on behalf of
Respondent number 1.
respondent number 1. Taking note of submission of Mr. Chaudhary, these content case stands closed.
Item 43.
May it please the lordship. But what has happened is that there is a subsequent development, my lord, departmental proceedings have been initiated against the original writ petitioner, my lords, and my lord, that fact, in fact, my lord, the initial notice to show cause was issued prior to your lordship's order. That fact was not placed before your lordship. And my lord, we are not otherwise aggrieved by the order because he has already filed an appeal. Lordship, but what had happened is that
the order of penalty was challenged by the writ petitioner by filing the writ petition. Lordship relegated him to the appellate remedy, which he has invoked, my lord, and that is pending. That is a different aspect. The only problem, my lord, is that the direction at page 18, my lord, the para 10 of your lordship's order, that within 60 days the retirement benefits are to be given. My lord, that my lord, is difficult because there is another proceeding pending against him. Charge sheet has been issued, and he has replied also to that. So pending that proceeding, my lord, this order, this part of the order, my lord,
Who has preferred an appeal?
no appeal. No appeal under the act, my lord, under the bank regulations. The writ petitioner has preferred because the lordship had directed him to go for the remedy, my lord, under the regulation. Your lordship will kindly come, my lords, to para 7, my lord, page 18. Para 7, my lord. After hearing the submissions of learned counsel both the sides, this court finds that the order dated 30/3/2015 imposing penalty upon the petitioner is an order which is appealable under Rule 50 of the Assam Gramin Vikas Bank regulation. No such appeal has been preferred by the petitioner, since the grounds urged in the petition are almost entirely pertaining to the rules, regulation, procedure and practice.
So why do you want a review of this order?
No, my lord, para 10, my lord, there is a direction by your lordship that within 60 days, my lord, all the retirement benefits are to be
If he
paid.
is entitled under the rules,
Lordship, if your lordship would make an
if he
observation.
is entitled, he is entitled. Otherwise, you file an appeal and get a stay.
No, no, my lord, lordship will kindly come, my lords, to page 29. The charge has already been issued after the.
Maybe, but if the rules does not permit, don't pay him. If the rules permit, you
One
have to pay.
observation from your lordship,
No,
my lord,
no.
otherwise, my lord, they will come in contempt.
No. If the rules permit, but you still don't want to pay.
No,
That is a,
of course, we
that
are.
is a matter you can agitate
Because
it.
that proceeding, my lord, has just been
Listen,
initiated.
Mr. Ganguly,
Lordship,
the bank is entitled to take his stand.
Lordship.
But these are not matters to be gone into in a review. This
My lord,
court has
only
given
for
a
that
detailed
part, my
order.
lord, because this direction otherwise would be problematic for us. He may come in contempt tomorrow because
He
60
will
days.
come, he will come, you have to pay, or you have to get it stayed in a appellate court. What can be done?
My lord, otherwise, we are not agreed by your.
How can the revisional court stay this now, having passed the order?
Look, lordship would only make an observation, my lord, that this was not placed before your lordships at that point of time. So if, my lord, subject to any departmental proceeding, any proceeding that may be pending in this, if that part would be clarified.
What was not placed? That another
My lord,
department proceeding.
Yes, that is one. My lord, in fact, what has happened is technically, my lord, it was started. 24th of April, it had already started, but the charge was not issued, my lord. The memo of
But
charge.
is it an expertise order?
No, it was a contested matter. Telephonic instruction was taken by the learned senior counsel, my lord. That part, that is the difficulty.
We'll close it.
No, only
You
an
do what
observation.
is in accordance with law, you can do, you do it. There is-
Only an
Because the
observation
order, the para 10 itself says
Yes,
that his dues are to be released.
which he may be entitled to under the rules.
If he is not entitled, don't give him.
No, lordship would only make an observation that if.
Heard Mr. Ganguly, learned counsel for the petitioner. This review petition has been filed seeking review of the order dated 22/5/2023. First in WPC number 6880/2015. The basic ground on which the review is preferred is on account of the fact that on the date on which the order dated 22/5/2023 was passed by this court, there was another departmental proceeding pending against the petitioner, but the said fact was not brought to the notice of this court. Full stop. The review petitioner is basically aggrieved by the direction contained in para 10 of the order, which is reproduced here in below. Para 10 is reproduced. Full stop. Full stop. I find from the record that the judgment and order dated so and so was passed after hearing the learned counsel for both the sides. Moreover, in para 10 of the said order, it has been clarified that the petitioner be paid his pension and other retirement dues, which within quotes, he may be entitled under the rules. Full stop. Therefore, the mere fact that there is another departmental proceeding pending against the petitioner would not modify the order unless the same contains direction which is contrary to rules. It is not the case of the petitioner that the directions contained in para 10 is contrary to the rules. Full stop. Under the circumstances, I do not find any good ground to entertain this review petition. It would be open for the review petitioner bank to take appropriate stand in the matter in accordance with law. Review petition stands closed.
But here in this case, my lord, the petitioner returned in 2018. And then, my lord, there was a specific direction of this court, my lord, to disburse the return benefit within an outer limit of 3 months, my lord. And that is now almost 1 year, my lord. Your lordship will find the direction, my lord, page 10, my lord. The middle para, my lord. There is a specific direction, my lord, and the petitioner is suffering from various ailments, my lord, at this stage, my lord, after retirement, suffering from financial hardship, but the, my lord, respondent is the DC Kamrup Metro, my lord.
Who's appearing in this case? DC is writing letters to the government advocate in contempt cases.
DC, my lord.
Just look at this and tell us what to do. If the DC writes letters to the government advocate, that is not a response to the contempt notice. Next matter, you just wait.
Lordship, item number 44, Lordship, it was not called Lordship. I think, as per information, it was closed, Lordship. Contempt matter, Lordship, I was.
No, it was not closed, it was adjourned.
Lordship, he said closed. Sorry, Lordship. Not sorry.
Yes, next item.
46. Can the matter be adjourned, my lord, for some days, my lord?
Why?
Because connected writ petition disposed of. Now, parties are going to file writ appeal, my lord. So, my lord, the contempt case is related to that order, my lord, actually. Now, if because writ petition not disposed of, not dismissed, even though it is not benefited for the parties, so they are going to file writ appeal. Therefore, my lord, the contempt is because 1 year term is there is already expired. Subsequent contempt they cannot file. Can it be adjourned for some days, my lord, or 1 month? The benefit given, but is only up to those who have crossed 40,000 basic. They will be entitled. They will not be entitled. But here the salary to be paid at par. So that is not maintained here in the order, my lord. So there is violation. So that's why I pray for the adjournment of the case.
How can it be? Who is appearing for the respondents here?
No, notice not yet issued, man. Notice not issued, man. This is a new
No,
one.
that we can't keep contempt matters like this. Then you withdraw with liberty to approach.
That 1 year term, that observation will be given. Because contempt, 1 year, that is from the order.
So this writ petition has been dismissed.
Not dismissed, disposed of. But the relief they have not got, my lord. So they are going to file writ appeal.
All right, then what? How can you approach in this matter again? You can't.
Because if the writ appeal succeed, then contempt will survive, my lord.
Mr. B. Sinha, learned counsel for the petitioner submits that the writ petition wherein the order of this court was earlier passed has in the meantime been disposed of by declining relief to the petitioner.
Yeah.
Petitioners, as a result of which a writ appeal is being preferred. As
Yes.
such, by granting leave to the petitioner to pursue appropriate legal remedy as may be permissible in the eye of law, this contempt case be allowed to be withdrawn.
Yes.
First up, taking note of submission of Mr. Sinha, this contempt case stands disposed of on withdrawal with liberty as paid for. Disposed of as not pressed with liberty as paid for.
Okay. Item 47.
Learned friend is appearing.
Lordship, thus now I have received the instruction, Lordship. I will file affidavit on behalf of respondent number 3, my lord.
You are appearing for?
Respondent number 3, my lord.
What about the other respondents?
Mainly, my lord, 2 is the drawing and disbursing officer. And the order, which is out of which the contempt petition has arisen, that is already within the knowledge of the authorities. In fact, I have filed an additional affidavit to place on record that affidavit, my lord.
These are not relevant. First of all, you have implicated 5 persons.
My lord. He is for the accountant general, my lord. Respondent number 3.
Who is appearing for the other respondents? That's what I'm asking.
None has entered appearance.
Lordship, there was direction to release the subsistence allowance, and I have instruction, Lordship, already released, Lordship.
As well as the provision of.
There is direction in the order, my lord, to release the subsistence allowance. As per my instruction, that has been
That
released,
is the only order.
Lordship, and in
No, my
respect of
lord.
provisional.
And also provisional pension, my lord.
Provisional pension is to be paid by the department.
Page number 13 is the operative part, my lord. Page number 13, the last paragraph. Page number 13, my lord, last paragraph. Taking into account Rule 22, my lord. This court directs the respondent authorities to forthwith release the provisional pension to the petitioner. My instruction is that he has not got any provisional pension as on date, my lord.
Mr. A.K. Borua, learned counsel is present on behalf of the petitioner. Mr. R.K. Talukdar, learned counsel has entered appearance for the respondent number 3 and seeks 2 weeks time to file affidavit. However, none has appeared for the remaining respondents. First up, in view of the above, office to leave this matter again after 3 weeks, along with service report on remaining respondents. In the meantime, affidavit on behalf of respondent number 3 will brought from the report.
Obliged.
Item 48.
It is for implement of the opposite party as the respondent number 4 in the contempt petition.
Had Mr. B. Sinan on a counsel for the applicant. There is the statements made in the IA. This application has been filed with a prayer to include the opposite party as respondent number 7 in the connected contempt case on the ground that the said opposite party is responsible for implementation of the court's order. Having regard to the submission made at the bar as well as the statement made in the IA, I am inclined to allow the prayer. As such, the implement application stands allowed. The opposite party, Sri Jayant Narlikar, is hereby implemented as respondent number 6.
Four.
Respondent number 4 in the connected contempt case. Office to, the applicant to file amended cause title within few weeks from today. IA stands disposed of.
Notice to him, maybe it should.
First, to file amended cause title. You must be aware of the notifications. Recent notifications say that you have to file amended cause title. This will be entered in the CIS.
Item 49.
Old days are gone.
Yes.
May, your lordship. So last occasion, government was directed to obtain instruction as to why the 7 years period is reduced to 5 years, lordship, although it is against the rules, lord.
Yeah, otherwise I have received the instructions. Yeah, lordship, this brief is as such was handled by Mr. Hrishikesh Sharma, but due to some personal difficulty, his nephew met with an accident yesterday. So today he is being operated upon. So he prays that the matter be listed on Monday, your lordship, as such.
We'll do it on Tuesday.
Lord,
Mr. A. Dekal and counsel is present for the applicants. On the request of learned government advocate Hassan, this matter is directed to be posted for orders again on Tuesday, 25 7. You have a copy of this instruction?
I'll provide.
You take a copy and see. what
Lord.
you do. Yes.
Obliged.
Item 50.
Please, your lordship. My lord, here.
My lord, we are yet to receive our instructions in this matter, my lord. We need further 2 weeks' time.
Lordship, only a date may be fixed if lordship pleases.
Yes. You are appearing for whom? Not Mr. A. Sharma, learned counsel for the applicant. That was the order dated 23/6/2023 passed by this court. Mr. R. Dhar, learned additional senior government advocate Assam, appearing for the respondent numbers. You may not be knowing who you are representing.
My lord, I'll appear for Mines and Mineral Fair.
Respondent numbers
1 and 2, lordship. For 3, we have taken steps by registered post.
1 and 2, my lord.
1 and 2 submits that instructions are still awaited and therefore this matter be listed again after 3 weeks. None has appeared for the respondent number 3, although steps for service of notice among the said respondent by registered post.
Small event পিছতে লৈছে আপোনাৰ কেতিয়া দিছিল
with AD.
ছাব্বিশ জুনত ল'ব লাগে দিব দিছে কোৰ্টে 27 জুনত দিছে
In view of the above, let this matter be listed again after 3 weeks along with office note on service of notice upon respond number 3.
Lordship.
That will be listed.
Please, your lordship. My lord, today, counsel for ONGC is supposed to appear. Notice regarding FR of joining, my lord. He's issued a FR appointment in as a permanent disability having 50% hearing impairment and appeared FR appointment was given. Now they are demanding for you because it is a exportation, their provision up to 25. Here 25 it was given him a disability. Now they want for permanent disability, ONGC one.
Yeah, there is already an interim order in your favor.
Interim order, Miller,
So-
and learned counsel for reviewing health department.
Take your seat. Let
Oh,
the
yeah.
respondent say yes.
Yes, yes.
My lord.
You want to argue afresh?
No.
Then I will see whether the interim order
No,
should be
no,
vacated.
don't regret.
My lord, I'm appearing on behalf of my senior, the standing counsel for the health department, my lord. My lord, we have received instruction. So as per the instruction, my lord, the temporary disabilities certificate cannot be, that cannot be converted into permanent.
You are appearing for respond numbers?
Respondent number 5, my lord. My lord, there is
Who
a
is respond number
notification.
5? Who is the respond number 5?
It's a disability medical board, my lord,
Chairman.
chairman.
And what about 1 to 4?
My lord, there is a notification which has been issued by the
You want
ministry.
to
of-
argue on merit today?
No, my lord,
Then?
just like to apprise.
File your affidavit.
My lord.
1 to 4, who is there for 1 to 4? Had Mr. C. Borwal on counsel for the petitioner, none has appeared for respond numbers 1 to 4. Mr. Your name please?
My name is Paul Tauthang, my lord. I'll give my name back.
Mr. So and so learned counsel has appeared on behalf of respond number 5 and prays 3 weeks time to obtain instruction, file affidavit, prayer allowed. Have you taken steps?
Yes, Miller, yes.
Let this matter be listed again after 3 weeks along with office note on service of notice upon respond numbers 1 to 4. In the meantime, counter affidavit on behalf of the respond number 5 be brought on record. Interim order passed earlier to continue.
My lord, that's.
Make it 4 weeks, 4 weeks.
4 weeks, Miller.
4 weeks.
I'm sorry, Your Lordship, I was only seen that
Yes.
document.
You have not filed affidavit.
My lord, but we have the instruction that the handmade industry, my lord, that it has been closed down. That is why these two petitioners were released from their services. And they were.
File your affidavit. Heard Mr. J. Abidin Learned Counsel for the lead petitioner also heard Mr. K. Munir. P.K. Munir Learned Standing Counsel Assam Khadian Village Industries Board. Appearing for the respond numbers.
All the respondents.
Appearing for the respondents who submits that as per instructions received. What has been closed down?
The handmade paper industry.
The handmade paper industry has since been closed down, as a result of which the petitioners have been released from service. However, on the request of Mr. Munir, this matter is directed to be listed again after 4 weeks, so as to enable him to place on record a short affidavit by serving the advance copy upon the petitioner's counsel. List accordingly. Yes.
Obliged.
Item 40.
Yes.
Meet with the lordship. Lordship, in this matter, my lord, the order reflects that, my lord, it were in two parts. My lord. One was that an appointment to the post of additional should be considered. The other was seniority, my lord. They had passed an order wherein, my lord, they have considered the post, but my lord, seniority part is not looked into. My lord. That part has not been complied in my respectful submission before.
Where
my
is the order?
My lord,
Which
at
part?
page 21, the relevant portion, my lord. Para 6, my lord, if I may read, my lord. Page 21. The next page, my lord, the first person is.
My lord, may I read the order, my lord? Having regard to the broad consensus arrived at the bar by the learned counsel for the parties in the aforestated manner, while closing this writ petition, including recalling of the earlier interim order, it is observed that the petitioner is, without prejudice to his other rights, at liberty to submit a representation before the respondent authorities in the Water Resources Department, setting forth all his grievances, including his prayer for consideration of the promotion to the rank of cadre of additional chief engineer therein, within a period of 2 weeks from today. It is observed that upon receipt of such representation from the hand of the petitioner, the competent authority in the respondent Water Resources Department shall give due consideration to the issues laid in such representation, and thereafter shall pass a speaking order by taking into purview the issues raised therein by the petitioner and also by taking into account the extant rules. It is further provided that such speaking order shall be passed within a period of 1 month from the date of receipt of representation at the office of the respondent number 2. Lord, this is important. While considering the representation, the respondent authorities in Water Resources Department shall also take into account the seniority of the petitioner in the rank and cadre, my lord, of superintending engineer and the rights of the petitioner as a member of the Assam Engineering Service to be
To be
considered.
considered for promotion. He has been considered and promoted.
Considered, my lord.
Heard
It says
Mr.
seniority.
Betala, learned counsel for the writ petitioner. Also heard Mr.
C. Sharma, Lordship.
C. Sharma, learned counsel appearing for the
Respondent number 2 and 3.
respond numbers 2 and 3. It appears that in terms of the order dated 39/2022 passed by the learned single judge in WPC number 6340 of 2021, the case of the petitioner has not only been considered, but he has also been promoted to the rank of additional chief engineer in the Water Resources Department by the notification dated
16/3/22.
16/3/2023. Mr. Sharma submits that the order of this court has already been complied with. Responding to the above, although Mr. Betala has argued that the petitioner has been,
Seniority in the cadre.
Mr. Betala has argued that the petitioner has been promoted, but his seniority as directed by this court has not been determined. On a careful reading of para 6 of the order dated 39/2022, I find that the direction of the learned single judge was only to take into account the seniority of the petitioner while considering his case for promotion. There is no order to determine the seniority of the petitioner afresh. Therefore, this court is convinced that the order of the court has been duly complied with. If the petitioner has any grievance pertaining to determination of this office seniority, the same would obviously be the subject matter of a fresh writ petition and therefore cannot be looked into in the contempt proceeding. The contempt case is accordingly closed. Yes.
Obligation.
My lord, I have seen the communication, my lord, very unfortunate, my lord. They should not have at least sent it to the court also. They send it to the registry. I will take it up with the DC, my lord.
Mr. M.A. Islam Learned Counsel for the petitioner is present on the request of Mr. R. Dhar, Learned Additional Senior Government Advocate Assam. Let this matter be listed again on 26th of July 2023 by reflecting the name of Mr. Dhar in the cause list so as to enable him to obtain necessary instruction. To find out, otherwise we'll ask him to personally appear.
My lord, I understand.
Yeah, what is this?
This is regarding pay scale, my lord. I have paid for pay scale of a sectional assistant, my lord. It was given for 1/10/2015, and I paid for 1/10/2005, my. That was the dispute, my.
It will require some hearing, some hearing day, your lordship.
Because the government has directed me to pay from 1/10/2005, my.
What is he saying?
Your lordship is not feeling well since yesterday. I told him that. That's why.
No, all right, this will require
Yes, not hearing, my lord, not much.
Mr. P. Kotaji, Learned Counsel for the petitioner is present. Mr. D. Bora, Learned Government Advocate Assam, appearing for the state, submits that since the matter would require full length hearing, the repetition be listed on a non-miscellaneous day for final or final hearing and disposal. In view of the prayer made at the bar, registry is directed to list this matter again for hearing on 10th of August,
Yes.
10th of August 2021 as a fixed item.
Oblige, your lordship.
Part two, any matter, part two? Anybody?
Lordship, I am there in item number 5.
Item number 5.
Yes, Lordship.
5 is over already.
Part 2.
Hmm.
Lordship, the matter may be taken up at 2.
You are for the petitioner,
No, Lordship, for the respondent.
but where is the petitioner's counsel? You make that prayer on Monday.
Okay, Lordship, obliged.